Get started.
Thank you, thank you, Brant, very much. Welcome, everybody. It is Monday, March 7th, 2022. This is a virtual workshop meeting of the Commissioners of the City of Rehoboth Beach. I want to welcome everybody here. I want to call this meeting to order at exactly 9:00 a.m. With that, I want to start off with roll call. Commissioner Tony Sharp.
Here.
Commissioner, welcome. Commissioner Tim Bennett.
Here.
Welcome. Commissioner Susan Gay.
Here.
Welcome. Commissioner Patrick Gossett.
Here.
Welcome. Commissioner Jay Legree.
Here.
Welcome. And Commissioner Ed Chrzanowski.
Here.
Welcome, everybody. And Mayor Stan Mills. We have a full complement of the mayor and commissioners and are formally able to make quorum and conduct business today. With that, I'd also like to identify in the minutes the attendance of Brant McCormick and Max Hamby helping to run this show from the IT department. Also, Ann Womack, City Secretary, helps run this meeting. City Solicitor Glenn Mandalis, City Manager Sharon Lynn, Building and Licensing Inspector Matthew Janis, and Evan Miller, Project Manager, is on board, as well as Kevin Williams, Public Works Supervisor. Thank you, everybody, for being here. And I see Howard Rothstein, also from Building and Licensing. It takes a lot to run a meeting. Thank you all for being here today. With that, I also want to thank the watchers, everybody that's watching virtually. And I'd also like to thank those that have pre-registered to speak in advance. And those members of the public who have pre-registered include the following: Kate Wall of Shorebreak Lodge Restaurant, Walter Brittingham, citizen, Melissa Postles of Egg Restaurant, Carol Everhart of the Rehoboth Beach Dewey Beach Chamber of Commerce, Cindy Lovett, citizen, Dr. Michael Trejos, citizen and property owner, and Michael Strange, citizen. Thank you all for being here. As you know, we value your input. We'll be calling on you at appropriate times during the meeting to garner your feedback and input. With that, I want to remind everybody that support documents, when they are ready, are embedded into the agenda, and you have many documents embedded in the agenda for today's meeting. Go to the city website. On the home page in the center right, there is a portal page, legislative portal. Click on that, search for the calendar, the date, and the meeting type, and you should be able to access the agenda and the agenda contents. With that, I want to identify that there's no correspondence received far enough in advance to have embedded in the agenda. We did receive some correspondence from citizen Mike Strange. So Mike, we wanted to acknowledge that. Thank you. With that, we'll go to the city manager's report.
Thank you, Mayor. Good morning, commissioners. As you know, the city will be returning to in-person public meetings effective next Tuesday, March 15th. Only those who are unvaccinated are required to wear masks in off city facilities. For the 31st time, I'm happy to report the City of Rehoboth Beach has earned recognition from the Arbor Day Foundation as a Tree City USA for its commitment to caring for and managing its public trees. Also, the city once again received the foundation's Growth Award for continuous improvement to its urban forestry program. Tree City USA communities must meet 4 program requirements. We have met those: having a tree board or department, a tree care ordinance, an annual community forestry budget of at least $2 per capita, and an Arbor Day observance and proclamation. The Growth Award recognizes communities that demonstrate increasing levels of tree care and community engagement. And the city will celebrate Arbor Day with a tree planting sometime in April. The date is yet to be determined. The Baltimore Avenue restroom will be reopened for the season starting April 1. Work is continuing on the Delaware Avenue restroom upgrades, and we anticipate that work will continue at least through May. Staff is looking at options for opening the restrooms while construction continues in May. Phase 2 upgrades for the wastewater treatment plant had a bid opening for Phase 3B, and that took place February 24th. The apparent low bidder at $7,641,000 is MF Ronca. They're also the Phase 2 contractor. 5 bids were received. We have scheduled maintenance of well 2R that has been completed by the contractor. Scheduled maintenance of well 8 has begun. The street staff has finished painting benches, is now working on lifeguard stands and trash barrels. Beach raking has been started again in preparation for the upcoming warmer weather, and weekend crews have expanded their work to better manage the increasing number of visitors over the weekend. That's all I have, Mayor. Thank you.
Thank you, Sharon. I have 2 questions. One is the Phase 3B wastewater treatment plant. The bid came in, apparent low bidder, you said was $7.6 million. Do you recall what the engineer's estimate was for that project?
It was approximately $6.2 million.
Ooh, ouch. Okay, thank you. And also, Susan, did you have any late breaking news on a tentative date for the Arbor Day celebration?
Yes, thanks for asking. I can confirm this at our regular meeting next week, but we are looking at Friday, May 6th. The April 30th, which is the official Arbor Day, is the week before. But there are some issues with the state staff at our Forestry Service, people who normally join us. There was a conflict that day because of some things they're doing upstate. So we'll be confirming it, but it's looking like it's going to be Friday, May 6th.
All right, thank you. Any other questions of the city manager?
Yeah, I have two other questions. Yes, Sharon, I got a question over the weekend about the new Lake Gerard tot lot, and I think I remember you saying before that even though the equipment's in, it's the surfacing that has to be put in before it can be opened. Is that right?
Correct.
Is there any idea of when that will be, and also whether or not it will open before the season? I mean, we've got a ways to go in terms of time and some nice weather. So
yeah, absolutely. It will be open before the season. It just needs to be warmer, so they can come in there and get that down.
Okay, so as soon as the surfacing is put in, it'll open.
Yes.
Right after that.
Correct.
Okay. My other question actually is something I experienced yesterday. I was walking back on Grove and State, and the sidewalk that is supposed to be put in there, on State Road where Munson and Grove meet. What's the status of that? It has not been started yet.
No, Mr. Williams can answer that.
Okay.
Thanks, City Manager. Thanks, Commissioner. Yes, that it's still on our books to do, and we still want to do it. We have not been able to get through the DelDOT permitting process and approval process for a planned crosswalk. Not really a sidewalk, but the crosswalk there at State Road. Still something we plan to do as soon as we get the DelDOT approval to do it. Looks like it'll probably get pushed until the fall after the season.
Until the fall?
Probably. We wouldn't want to do it if we can't get it completed before, middle of May. So if we get the approval, we could probably get it out on the street and awarded. Not sure about getting it constructed before this season.
Okay. All right. Thanks.
Thank you. Commissioner LeGree?
I have a couple of questions for the city manager. The $7.641 million for the Phase 3B. When you add the contingency, the design, and the construction management, what do we end up with? Any ideas yet?
Well, we're still looking into that, and my plan right now would be to bring that forward to you at your regular voting meeting so we can discuss it further, unless Kevin has something he wants to add.
Nothing really to add other than the fact that we're negotiating with our designer now on the fee for the construction management. Obviously, we talked earlier in the budget meetings about the State Road pump station. So we think we're going to be able to have some efficiencies because both of those things will be going on at the same time, and we can use, one construction manager to kind of take care of both. So we're working through that process with them now. We'll have a full full breakdown on at the next regular meeting.
And this was the same phase 2 contractor. Were they working on South Coastal at the same time they were working with us?
Yes, that's
our
correct.
phase 2?
Mm-hmm.
Kevin, I think you answered yes. We just didn't hear you.
Yes, that is correct. Same
Okay,
contractor.
and will we continue to have those same kind of efficiencies going forward on 3B?
We hope so. Certainly, if we get the award to Ronca, we would expect to see those same efficiencies. And we believe that's why their bid was significantly lower than some of the others.
Thank you, City Manager.
Thank you.
Thank you, Commissioner. With that, I don't see any more questions from the commissioners. We'll go to City Solicitor's report. Glenn?
Good morning, everybody. I just wanted to update you on the clear space litigation, but the update is that there is no update, but I failed to give you an update last time. So that case remains in a holding pattern. Remember, there's some argument about what constitutes the record. So that issue has been briefed to the court, and the court has not made a decision yet on to who's right as to what constitutes the record. So until the court does make a decision on that, that case is sitting kind of in a steady state. The other thing I wanted to update you on is on February 23rd, there was a writ of certiorari filed in Superior Court, which challenges the granting of a variance to the Bellhaven team for construction in the C1 district at a 3.0 FAR rather than the 2.0 FAR that's provided for in the code. So that case has been filed. It, like clear space, is in its infancy. The next thing that'll happen is we'll have to send the record up to the court, and then we'll start a briefing schedule after that. So, but that has been filed and it's now in active litigation. Are there any questions?
And anything else?
That's it, Mayor.
Hearing no questions from the commissioners, we'll move on to next item of business. Thank you. We'll go to two committee reports. They both happen to be chaired by Commissioner Chrzanowski. The intent here is just to hear a brief oral note on topics from the two committees noted, but not to engage in discussion. As I understand, Commissioner Chrzanowski would likely put these on the regular meeting agenda of the 18th to see if we have further discussion. Go ahead, Commissioner Chrzanowski, on the Environment Committee, please.
Yeah, thank you, Mayor. I just want to give a brief update. The Environment Committee has suggested that we implement a climate action plan and is looking for the mayor and commissioners to provide some insight on how best to accomplish that. So that's one update from the Environment Committee. On the Streets and Transportation Committee, they're asking that the city, DelDOT is, I think, planning on resurfacing Rehoboth Avenue in the near future. And they're asking that the city encourage DelDOT to look at the feasibility of potentially putting in a crosswalk between 4th and 5th Streets on Rehoboth Avenue in that process of planning the resurface. The Streets and Transportation Committee is also, this wouldn't be in effect until next fall, but that we encourage, that the city look at potentially doing year-round no left turns on Rehoboth Avenue. Those are the two updates on streets and transportation.
All right, thank you very much. So, yeah, go ahead.
And Mayor, I defer to you when to best put these topics on any workshop meetings.
Sounds good. Thank you very much. Any questions? If not, we'll move on to old business. Old business number 8, discuss proposed changes to the small wireless communications facility design manual as referenced in Chapter 270 zoning of the municipal code, specifically 270-46.1.2 wireless communications facilities. If you recall at our last meeting, we talked about the design manual, and at one point we focused on BATEA, BATEA. In our last meeting, the consensus was in lieu of BATEA to seek out alternative language, and that has been done. So we present that to you today as authored by CTC. And I think there's some additions from Glenn. Again, this is a support document that is available online. With that, Sharon, we'll turn it over to you or Evan or whoever.
Well, I'd like to just follow up and have Julie on? Julie Elias, our, Julie, are you on?
Coming on.
We can just hold on 2 seconds, Mayor.
Mayor, while I'm contacting Julie, I'll just provide you with a brief update of some of the changes that were made to the wireless design manual. This is Evan, by the way.
Yeah, Evan, and we may want to put it, share the screen with it if you have it.
Sure. Mayor, I have to make an adjustment to my system preferences in Ring Central. So just briefly, what I'll do is I'll go over the highlights, and then once I'm able to get a minute to change those, I'll share the screen. But in the support document, which is provided in the agenda, it has an updated version of March 3rd, 2022. Again, this just incorporates a few changes which are highlighted at the top of the document. So first and foremost, there was language that was inserted, which was provided by Glenn, which includes terminology that was taken from the FCC's rule. And this terminology was added to the top of Section 2 as part of Section 5 and as part of Section 10, I believe, following the design zone map. Inserted in several areas were also referenced that all small wireless communication facility installations must meet the most preferred design options for that zone or otherwise demonstrate why it is not technically infeasible to meet those most preferable designs. We also had added a boardwalk zone definition. This was some of the discussion that had taken place at the last meeting about how to better define that boardwalk zone. You'll recall there was a reference to some of the light poles that currently exist east of the boardwalk, but during that discussion, we identified that although those structures are located east of the boardwalk, they are attached to the structure of the boardwalk. And then we also added a definition for the design zone to the definitions listed on page 2. I will say that the boardwalk definition was actually taken from the city's existing code. So it's consistent with the boardwalk definition in the code currently. We did just tweak it a little bit to make it applicable to this design manual. And that's all I have, Mayor.
Well, thank you, Evan. Before we turn it over to Julie, I see Commissioner Legree, you have a question. Get to you in 1 second, let you go first. I would like to say that I think today's goal should be to finish a total review of the wireless design manual. If we fail to come to a consensus on the BATEA or the alternative language, so be it. I would still like to finish review of the design manual so that we can move forward. As I think the commissioners know, the public may not know, Verizon has withdrawn their applications for antennas on the boardwalk. Is that how they worded it, Sharon? Withdrew applications?
Yes.
You're muted.
Yes,
Oh, yeah, they withdrew their applications. That doesn't mean they can't resubmit with new parameters. So we need to get this thing on the road. So before we go to Julie, Commissioner Legree, did you have a preface?
I'm just going to ask Julie if she feels like this gives her adequate protection in the future, and then I'm talking lines 102 to 108 or 107, and which is the real battle that we were not battle, but the real center of the problem that we were talking about. And I'll just ask her if she thinks that gives her adequate protection. I'm assuming that, Glenn, you were the one who reworked this between the last meeting and now.
I did, Commissioner. The thing that we struggled with and tried to figure out, and I don't think it's a perfect solution that's going to satisfy everybody, but we really came down to a question of what are we trying to address? And I think it was more about aesthetics than actually the type of technology. So we looked to the FCC order as to how did it deal with aesthetics and what is permissible when it comes to aesthetics, and what language can we use. When you tried to lift that language and put it right into our ordinance. So the order, and remember, parts of the order were struck down by the Ninth Circuit. This portion was not. So this is still viable language. That order says, and this is paragraph 30 from the FCC's order titled Accelerating Wireless and Wireline Broadband Deployment by Removing Barriers to Infrastructure Investment. So it says there, like fees, compliance with aesthetic requirements imposes costs on providers, and the impact on their ability to provide service is just the same as the impact of fees. The Commission therefore draws on its analysis of fees to address aesthetic requirements. The Commission explained above that fees that merely require providers to bear the direct and reasonable costs that their deployments impose on states and localities should not be viewed as having the effect of prohibiting service and are permissible. Analogously, and this is the language we adopted, aesthetic requirements that are reasonable in that they are technically feasible and reasonably directed to avoiding or remedying the intangible public harm or unsightly or out of character deployments are also permissible. So the FCC said you can implement a requirement that says that the city is able to impose aesthetic requirements that deal with remedying the intangible public harm of unsightly or out of character deployments. So we just looked at that language, put it right into the ordinance. So I think if there's ever a challenge to it, we're able to say this isn't language we came up with. This is something the FCC has already said is legal. The Ninth Circuit challenge didn't strike that language down. So it was our best attempt at crafting something that would allow the city to say, aesthetically, you have to do this because it's an intangible, we're remedying an intangible, unsightly, thing that we don't want. So that was the best we could do, Commissioner. And I hope it kind of evens out what we were trying to, address.
Yeah, I think you've really checked off all the boxes, and I'm just wondering if the consultant feels like she's given the adequate protection with that narrative. Thanks, Counselor.
Julie, are you on yet?
Yes,
Yes.
Julie's on. You want to go ahead and respond, Julie, to Commissioner Legree? So obviously we're starting with Batia or the Batia alternative. So let's go ahead and carry this through before we go to the rest of the design manual. Go ahead,
Absolutely.
Julie.
Commissioner Legree? Yes, absolutely. This definitely provides significantly more protection to us, to you, for looking ahead to the future. I think that using the language directly from the FCC, especially language that was not struck down by the Ninth Circuit, is really going to help any challenge that might come about for future deployments that, again, are unsightly, are aesthetically unpleasing, that really don't protect the view sheds that you have on your streets in the city. I think that this is really it really does provide sort of a protection that, again, it's not just a capricious rule that you came up with for yourselves. It's coming straight from the FCC and is applied universally across the country for any any jurisdiction looking to protect their streets for aesthetic purposes. And I think that if, as a result of that, there are specific aesthetic requirements that you currently have, or that a couple of years down the road, we start to see an increase in applications for installations that are, consistently along the lines of that more unsightly, undesirable look, we can then come back to the board, to the commissioners, and look at making actual written changes at that time, specifically addressing what you're starting to see, but that in the interim, you'll be able to still be protected against those types of unsightly installations in the meantime. I think it was Commissioner Gay had mentioned at a previous meeting that, the idea here is you don't have to every couple of months, every year or two, come back to this and look at it again. The idea there being that you would come back to relook at this with a very specific intent to update it at that time, because you will know exactly what you're looking to protect against, because you're getting examples of unsightly and visually unpleasing installations at that time. Does that make sense?
Yeah, and I'm happy that we have a year or so to let this settle in, and it seems like we're going to have. But I suspect that what you described down in the future is probably going to happen, and we're as ready for it as we can be. And I'm okay with the rest of the design manual, Mayor.
Thank you, Commissioner. Commissioner Gossett?
Yes, thank you. Just curious in this regard, the language of what you've outlined here in 102 to 106 versus the Batia language. And was it my understanding that the Batia really works in the advantage that we don't have to come back and identify those issues, that Batia is proactive in the sense that kind of is a one size fits all in that regard, but with coming back with the language suggested that we then would have to come back and describe those specific aesthetic requirements. Is that either Glenn or Julie, if you could kind of comment on that?
I'd be happy to. I think what Julie's describing is that probably as we see applications come in, some themes will develop as to what, we're seeing that maybe we don't like aesthetically. And rather than having to just rely upon this language, we will perhaps be able to suggest language to you over the years to add to the ordinance. But we think this language is sufficient right now. The issue, in my view, with Batia is that every place we've seen it implemented in regulation, it occurs at the federal level. And to try and implement it at our level, it's just really an overwhelming task, in that, we really tried, I thought last time, to figure out what are we trying to address. And best available technology, economically feasible, can mean a whole lot of things to a whole lot of different people. It can be aesthetic to one person. It can be the smallest, most refined technology. It can mean, there's just a whole wide world of things that it can mean to different people. And when we learned that what we think the commissioners were trying to address is mostly what's the best available when it comes to aesthetics, that's why we focused on this language that's from the FCC order that we believe we can rely upon for best available in the aesthetics realm.
So if a carrier comes to us to present something and we feel, or again, whether it's building and licensing that says, I don't think this is the best aesthetic requirement, and we don't define it as such in either the design manual or the code, then it has to come back to us to specifically call that out as we don't like that?
No.
Okay.
I think you'll be able to rely upon this language and say, in the context of this proposed installation on this street, with this streetscape, with these surrounding things, here's an additional requirement we're going to impose upon you based upon this language. And so long as it's not arbitrary and we can support that additional requirement, I think this language gives us the flexibility to do that. I'm only indicating that if we see over the next 10 applications, in 7 of those applications, there's an additional aesthetic requirement that we impose based upon this language, we might want to just insert it in the code so it's very clear that this is a requirement for all applications as far as aesthetics go. But I don't think but I think this language is sufficient as it stands to impose some of those aesthetic requirements, so long as they're not arbitrary and we can support them with real world evidence.
Okay, and Julie, not to put you on the spot, but is another one of your clients a municipality in Delaware also considering the use of Batea language?
Not to the extent that you all are. They have been considering, I believe, the use of Batea language as sort of a broad policy idea in terms of the least aesthetically obtrusive overall, and using the best technology to do so. But again, in order to actually enforce that, they are not looking to create or really implement that as a across the board policy that involves, you know, confirming that the technology being used is in fact the best available, that the options for designs for that particular installation is the least aesthetically obtrusive in that regard. It is more of a sort of, as a location, we are looking to enforce that everything is as aesthetically pleasing as we would like it to be.
So that's functional for that other municipality, but not for us? I'm not clear.
The functions that you are looking to use Batea for, they are not looking to use it in that regard. They are looking to simply say that we are looking for, and in fact, I believe, I'm trying to find the exact location, but there's another location within your design guidelines already that speaks to basically exactly how a different jurisdiction is using this language, which was, pardon me. I believe it's under the Section 2 General Standards for Small Wireless Facilities. So this would be line number. Actually, yeah, it's goodness, it was in, oh, sorry, line number 121. There it is, item number 6. All small wireless facilities shall be designed and constructed in an effort to minimize aesthetic impact to the extent technically feasible. That is the statement basically that a different jurisdiction is looking to make, but are simply claiming, using the language Batea, the best technology economically achievable to do so, and then leaving it there as is. I believe what we're really looking to do here is to, on a case-by-case basis, evaluate what does that really mean? How are you going to implement that? How does it play out in real time? And in particular, so that you can, when you have an application that comes in for an installation that is less aesthetically pleasing, how are you going to use that to combat that? And it becomes significantly more challenging. In this regard, the language that we have pulled straight from the FCC, we think is a much stronger protection in that regard, and will allow you to make changes and to push back against unsightly deployments in that regard much more strongly.
Okay, thank you.
Thank you. Commissioner Legree?
Line 122, 121, 122 is kind of aspirational, whereas 102 to 107, Glenn put, there's nothing aspirational about that. It's directive, and I like it for that reason. Thanks.
Thank you. Is there any more commissioner questions specific to Batea alternative language? Let's finish this topic. If not, I'm going to go to the public. Anybody? All right, we'll come back. I want to go to the members of the public first. For those that have never been online, this is your opportunity to give us feedback on the specific topic we're talking about, which of course is wireless, and certain language about preferable design options for the zone and technically feasible, etc. If you have nothing to say, then just say pass, and that'll be sufficient. We'll get back to you again. Kate Wall, any in fact, I don't see you on. Kate, are you on? I don't see her on. Walter Brittingham?
Pass.
Thank you, Walter. Melissa Postles, are you the same as Melissa Moore?
Yes, correct.
Any comments on wireless?
No, pass.
All right, shall I save you for outdoor dining? All righty. We've got Carol Everhart.
Pass.
All righty. Cindy Lovett. Dr. Trejos.
Pass.
Give Dr. Trejos a second. Dr. Trejos, are you available? Dr. Trejos may be on and off today. Michael Strange. Oh, there he is. We need Dr. Trejos. We need you to unmute yourself and go ahead. I see we have Sean Thompson of CDC join us. Thank you. Welcome aboard. Dr. Trejos, are you there?
He's unmuted, but seems to be having problems with his audio.
All right, we'll come back to you, Doctor. Michael Strange, are you there?
Yes, sir, I am. Thank you very much. Yes, I'd like to comment specifically. I know I sent in a submittal, but it may have not gotten fully distributed because I, quite frankly, did it late. I generally agree with some of the wording that Glenn came up with. However, I think it is still necessary to have BATIA in there as a defined term because it gives you the coverage that you need so that you can address unanticipated developments and changes over time. I unfortunately think one of the things that's happened here, it goes back to a meeting that was held a month ago where a document was read into the record by the representative from Verizon, and the representative from AT&T agreed with it, and they were materially false statements of facts that I think poisoned the discussion from that point with regard to BATIA because they objected to it. And the reason I say that is because previously commissioners, in fact, Commissioner Gay had said, we don't want to have to constantly come back to revisit these issues. And what BATIA does is permits you from a technology standpoint to not have to come back and revisit these issues. That is not addressed by virtue of the new wording that was put in by Glenn. Although I think it's excellent and extensive and very, very good, it really is a preface to where you can also define BATIA. Commissioner Chrzanowski had said, can't we find other words that do the equivalent of BATIA? And that's exactly, I think, what Glenn tried to do. But what's still missing is that key element, the overarching definition that allows you not to come back and revisit because I, as well as you, are not omnipotent in our ability to know the future. We can't. Amazing things happen at various different points in time. So in order to come up with a regulation that really stands the test of time and represents a very good policy document is to insert BATIA along with the language that Glenn has in there. Now, I think it's important to note that previously it was stated by CTC, and I agree with all the other recommendations they have in there, that it would require hundreds of pages of documentation to define BATIA, and that you'd have to constantly refer to that. It would be difficult. You may have to hire more consultants. That's absolutely not the case. There are numerous guides with regard to this in the technology world, from the IEEE, other organizations, peer-reviewed documents, guides for the building inspector and others and the commissioners to look at from the standpoint of what is the current available technology that you should be applying. Given the standards that were put in the code with the maximum dimensions, and I gave an example with regard to side setbacks for building lots, if you leave what's in there right now, notwithstanding the zones that have been created by CTC, which are all very good, everything that goes in will be maximized to what's permitted under the law. When in fact, technology exists even today where it could be far smaller than that. And yet there's nothing that you'll be able to do to stop it, even given the current code, unless you install Batia into it. Basically, that's it. That's my position. Totally based on facts and evidence and not opinion. With that, and I assume Dr. Trejos is back on, but he did want me to mention that he wanted me to comment on the fact that none of this that's being incorporated into the code applies to amateur radio operations, which have previously been preempted by what's called PRB 1 under Section 704 of the 1996 Communications Act. So anything that's done here with Batia or with regard to small cells does not impact that particular population. I thank you for the ability to talk today. Thank you.
Thank you, Mike. I will offer that I'm not tainted by the statements from AT&T and Verizon. I think that the language that we have is reasonable and would like to see us proceed. Dr. Trejos, are you back available? He's working from his office. Keep working on it, Dr. Trejos, and we'll come back to you. With that, let's see, that's all of the public comment. Are there any further comment by the commissioners? I would like to say that for the purposes of moving forward toward a public hearing to adopt the proposed amendments for wireless code, as well as the design manual, that this is acceptable and ready to go forward. Is there any further commissioner comment before we go to the rest of the design manual? Here, we got Commissioner Gossett. Go ahead.
My comment is to the rest of the design manual. So
yeah, go ahead.
And I guess this is a question for Glenn. There is a map, the proposed small WCF zones and map. Will that be adopted as or codified as a map, an official map of the city? And if so, will we have further definitions other than just the color-coded map?
I don't think, Commissioner, it's intended to be any place other than in this design manual. For example, I don't expect it to make it into the comprehensive development plan as an official map of the CDP. It might at some point, but there's no intention, as I understand it, to do that now. I think this just rides along with the design guidelines.
But again, I'm just trying to think forward here in the sense that if it is challenged by someone or a carrier, and it's, quote, not an official map, it's just part of the code. I mean, map carries a different level of authority, if you will, than code language, correct?
Well, in a CDP, there's a distinction between maps and text, but not in the municipal context. So in the state code, a county comprehensive plan, so this is for Sussex County, Kent County, Newcastle County, their comp plans, for some reason, and I've never really understood it, the state code says the maps in those CDPs have the force of law. So they are the most significant part, in my view, of a county CDP. But in the municipal section of the state code, Title 22, it says that both the text and the maps have the force of law. So in the CDP context, whether it's text or maps makes a big difference in a comprehensive development plan for a county. Here, this is a map that's going to be in the guidelines. Remember, the guidelines are referenced within the zoning code. So the guidelines are codified by way of reference. So I do think this map has the force of law in that these zones are real zones that are established that define different requirements for small or for wireless facilities. So it is, does have the force of law in that context, but I don't think it carries more weight than the text definitions of the zones, because I think that, it's kind of on the same level. It's in the design guidelines, the text and the maps. There's nothing in state code that distinguishes between maps and text in a municipal code.
Okay, but do we define, or is it necessary to define anywhere the actual street boundaries of these zones, or is the acceptable colored map enough?
Maybe Evan's able to comment on, because we talked at one point about the resolution of the map and how detailed it is, so that if we had to go in and actually see how well defined it is, and I don't know where that ever ended up, to be honest with you. So Evan, are you able to comment on that?
One thing I'll just add is I know, we've added some of the street names within the Boardwalk adjacent buffer because there was a lot of discussion on that zone. And there's, setbacks and things like that, or distances spelled out within that Boardwalk adjacent zone. But Max may be able to comment on this, but I imagine that the map that was created is something that's available in a GIS format where if there is a question as to the granularity of particular zones, that could be looked at further by going into a GIS system and, again, looking at each zone in more detail.
Well, let's do that so that we're very clear. If we could further research that. Anything else, Commissioner Gossett?
Not at this time.
All right, thank you very much. Any other questions from the commissioners? Because the next step is I'll go to the public one more time to see if they have any comments on the rest of the design manual, and then we'll come back to the commissioners. So this is for any comment absent Batia language. Kate Wall, I'll come back to you for outdoor dining. Walter Brittingham. All right, thank you. Melissa, I'll defer to you on the outdoor dining topic. Carol Everhart, anything on the rest of the design manual?
Pass.
Thank you. Cindy Lovett, anything on the rest of the design manual?
Pass.
Dr. Trejos, are you there yet? Keep trying. Michael Strange, anything on the rest, the balance of the design manual?
Yes, sir. Just one very specific element with regard to the lines 310 to 319 under approvals.
Give us a second to get there. 319.
Yeah, I'm looking at the summary on my end. With regard to the enforcement officer having the authority to issue a variance to code, with regard to WCF specifically. And I think that, in fact, none should be permitted. Whether or not you implement other facets of the code from the standpoint of the language that Glenn developed or Batia, that in this particular unique situation, that the enforcement officer does not have the right to issue any variance whatsoever. And as I made a comment in there, which I'm not totally clear of in looking at the law, but it seems to go in that direction, is that if a variance was to be considered, it would have to go to the Planning Commission for consideration.
Thank you, Mike. Glenn, do you interpret it the same way?
So I want to take this is an area that I'd like to take a closer look at, because as Mr. Strange was speaking, so this design manual is referenced within the zoning code. And I do get a little bit concerned when we talk about variances, who has the authority to issue a variance per se. It might be a terminology thing, but if you allow me to take this under advisement, I wouldn't hold it up for public hearing purposes, but it is something I'd like to take a closer look at.
All right, thank you. So I think there's two follow-ups we need to do in this specific topic, as well as the map that and the questions that Commissioner Gossett posed. Glenn, would you please refresh our memory on the next process? If you recall, everybody, we voted some months ago to adopt a resolution setting a public hearing to adopt or consider the wireless code, which is in the zoning code. And yet at a subsequent meeting, we decided to defer on continuing with the public hearing to wait until the design manual could be considered at the same time. So where are we in that process, Glenn? Has so much time passed that we need to start over with a new resolution adopting and setting a new public hearing, or can we just announce it in the in an agenda, go forward?
Well, that's a good question. So I didn't look back at it, but you're right. You did adopt a resolution as to the design manual. I don't remember, the reason I'm questioning is I don't remember whether that resolution was broad enough to encompass both the code language and the reference design guidelines, or if it was just the code language.
The resolution was specific to the one change in the wireless ordinance.
I thought that might be the case. So I think, Mayor, you need to adopt a new resolution incorporating both the code and this. Since the time has passed, you might as well notice them both. Both the code and the design guidelines. Set one date for a public hearing as to both items. It's gonna be hard to bifurcate them anyway. So I think it's your regular meeting this month. We'll have a resolution ready to go for you to do that if that's how you'd like to handle it.
Yeah, that would be the next step, and also it would be beneficial to accelerate the addressing the two follow-ups that we've talked about tonight. Is there any further comment from the commissioners? If not, then we will go that direction and expect to consider adoption of a resolution setting a public hearing to consider both items, amendments to the wireless code, as well as amendments to the design manual. With that, there's no further comment. I want to thank everybody. Thank you, Julie, for your input there. Glenn, for your input. Evan Miller, Mike Strange, and all the public for speaking up. And we'll move to the next, we'll close out this item of business and move to the next one. Thank you, Julie. Next bit of old business is discussion of outdoor dining on public space policy. If you recall, this is session number 2 on outdoor dining. We first introduced this hang tight. That's the wrong one. Hold on a minute. Hold on a second. Get somebody from IT down here real quick. Hold on, I'm trying to work on something. Oh, here we go. Can you see on the screen right here, version 2, March 7th? Anybody there?
Yes.
I see March 1st presentation date.
Hey, hold on. I've got 2 PowerPoints here. I'm trying to get this one on to share screen. 7th. There we go. You got it. Thank you. And IT comes to the rescue. Thank you very much. Let me. My apologies. IT helped me out here. We're going to start off this discussion with a very brief, compared to the last meeting, review. And then Commissioner Gossett's going to get into the permitting process. So we're going to go through this entire thing again. and then give you all, the commissioners, the first opportunity to bring up topics that we may have broached at the last meeting. And we will take more time to consider those before we move on today. So then we will, of course, go to the members of the public. So again, this version is dated March 7th. It's very much condensed from the last time. I just want to reiterate that the colleagues here that we worked with are Commissioner Gossett, City Staff Evan Miller, Howard Rothstein, Matt Janis, and City Manager Sharon Lynn. The applicability for this, as we said last time, was for restaurants only. And we defined restaurants using the city definition in the zoning code, an establishment where meals are prepared and served on the premises. This is a different entity than food establishments that is also defined, but which does not sell prepared meals such as pretzel places and ice cream stores. Again, the definitions very quickly: outdoor dining on public space. Public space means a portion of a city sidewalk. We needed to define certain terms because they're part of a formula for determining whether or not an outdoor dining area can be used in front of a restaurant. We defined buffer as the area between the curb line and the outer edge of the pedestrian access route. We defined the pedestrian access route as the primary pedestrian way within a sidewalk, defined by parallel sides and free of obstacles. We defined the sidewalk depth as the outer edge of the pedestrian access way to all the way to the face of the building, not necessarily the property line, but the face of the building or the face of a structure, such as a fence, etc. So sidewalk depth is part of our formula. We talked about the outdoor dining area depth as the area from the front of the building or structure out to the, generally probably the inner edge of the pedestrian access route. And that's the area that we would allow to be permitted for outdoor dining. We talked about separation barriers, that they need to be freestanding, etc. There's more rules to it. We talked about the foundational philosophies that form the basis for the policy on outdoor dining. And these are what we started with first. And then from here started to create the policies and the design standards and the rules. And you can see right there what the three top philosophy policies were. So we'll get right into the design standards review. Maximum permittable outdoor dining area. The last meeting we had said the maximum allowable dining area is 750 square feet total for the sum of the patio dining areas and the outdoor dining area on public space. We just started off with that because currently the patio dining area has an existing 750 square foot total. And so we just started there. We reviewed the permissible outdoor dining layouts. And we said that the 2-table and a 4-table layout is only the table layouts that were permissible. And we made reference to the dimensional requirements there, that you have to have a table depth, you have to have a 3-foot service aisle that is clear, you can have up to a 1-foot separation barrier, and that dictates for a 2-top table a minimum of 6-foot depth in the dining area, and for a table for 4, similarly, service aisle of 3 feet, separation barrier means a minimum of 8-foot dimension required to have a 4-top table. Further, we talked about the area outside of the barriers and how important, if you recall, we said one of the foundational philosophies is that you have to have a adequate, sufficient minimum pedestrian access route. And as we talked last time, we mentioned that building and licensing had surveyed the town and determined that 7-foot, 8-foot, or 10-foot or greater minimum pedestrian access routes were required in order. And so you can look at the philosophy here. The minimum sidewalk depth is the sum of the minimum dining area, 6 or 8 feet, plus the minimum pedestrian access route, which would either be 7 foot, 8 foot, or 10 foot. In this example, if we use 7 foot, then the minimum sidewalk depth would be 7 foot for the pedestrian access route, plus 8 foot for the four-top table, means a 15-foot minimum sidewalk depth is required. We gave an example, so that hopefully was helpful for everybody to understand the process, especially if you were a restaurant, to be able to determine if you can have an outdoor dining area on public space. First, you determine the outer parallel line of the pedestrian access route. Then you determine from there, you measure into the building and determine the sidewalk depth. Then you would subtract the sidewalk, the dining area, 6 foot or 8 foot from the sidewalk depth, and that would yield you a balance. In this example, in the third block of Rehoboth Avenue, the minimum pedestrian access route is 7 feet. And in this example, with a 6 or an 8 foot dining area, that would yield 11.5 or a 9.5 foot wide pedestrian access route. So in this scenario, if this were to be a restaurant making application based on sidewalk depth only, they would meet the criteria. And so with that, I want to turn it over to Commissioner Gossett, who's going to review quickly some of the rules and then get into the permitting process. And again, we'll offer the commissioners first any questions and discussions, and then we'll have comments from the public also. Commissioner Gossett.
Hey, thank you. Let me see if I can share my screen here.
Well, you do better than me.
Well, I don't know about that, but so again, just to go over the rationale and the policy here for outdoor dining, as the mayor discussed, we've reached back to 100% capacity after the governor lifted the emergency order. The pedestrian use of the public sidewalk is expected to return to pre-COVID density or greater by comments from the Chamber of Commerce and also real estate agents that their rentals are very strong for the season. But again,
are you sharing your screen?
I am.
Because we're not seeing it.
All right. Well, maybe you spoke too quickly. Let's see here. How about now?
You got it.
Okay.
Thank you.
Thank you. So let me go back here. There we go. So that was the first slide we went through there. And then we go to talking about dates of operation. We're currently talking about April 1 through October 15th. And in doing this, we would also instruct that if there was outdoor dining may be suspended by the city manager for community or special events such as Sea Witch or what have you, some races, utilities, sidewalk, road repairs, emergency situations, etc. Length of suspension will be for durations determined by the city manager. And at that point, the removal of the tables, chairs, related obstructions, responsibility of the restaurant owner. The same thing is true if the dining area should be closed for longer than seven consecutive calendar days. Again, if the restaurant decides to close for some reason, at that period, they would again be responsible for removing those materials. Next is let's see here, food and beverage service. And again, these are coming basically from our current patio ordinance, that food and beverage may be served only to seated patrons. No bar in the outdoor dining area. There should be no food or beverage preparation in the dining areas, outdoor dining area, and the permitted outdoor dining area shall end all food service and beverage service at 11 and then close. All patrons must vacate by 11:30. Targeting the entertainment aspect, again, these are from our current outdoor dining on patio. No live entertainment in the outdoor area, no external speakers or amplifiers, no internal speakers pointed outside. And we also will certainly enforce Chapter 189 of our noise ordinance. Let me get to the design and layout of this. And this is, again, for outdoor dining on public space not able to block public ways, pedestrians or vehicle blocking is prohibited. No operational items such as the hostess stand, menu stands, that type of thing outside of the permitted area, outside of the barriers. Again, this would block pedestrian access. And no tables may be placed within 6 feet of a takeout window. Again, the crowding out around a window such as Coors Brothers or French fries, what have you. And again, very important that we don't block any entrances or exits or ADA accessible areas. Also, the establishments need to mark their areas that are readily identifiable by visible markers, so we know where the boundary lines are throughout the season, if you will. No overhead wiring allowed of a pedestrian pathway. Again, that would conflict with pedestrian access. No wires affixed to street trees. And the outdoor dining on neighboring public property is not permitted. Talking about maintenance, just keeping it clean, clean and orderly manner. Spills of food and drink and trash of any kind must be cleaned up. And the outdoor trash to be collected and deposited in the private trash receptacles, not placed in the city trash receptacles on the street right in front of the dining area. Also, that only directional signage will be allowed on the barriers, not to exceed 2 feet, and only really identifying the entrance and exit of the permitted dining area. Umbrellas, again, of our policy the past summer, 7 feet vertical clearance, 8 feet maximum diameter, again, for pedestrian safety. And we're not permitting any tents or canopies at this period. And in the off-season and when heaters are needed, the same policy that was in place for the last 2 years about the operation of heaters outdoors. And again, highlighting again the Americans with Disability Acts, dining areas shall be on public space, shall comply with all ADA codified rules. Tables and chairs cannot block any entrances or exits or ADA accessible areas. And the aisles with aisle widths must meet the ADA and fire code requirements within the outdoor dining area for exits during a fire emergency. Then we go into some things that are not permitted in this type of thing, is the use of the full depth of the public sidewalk, as the mayor had described in his visuals there. Parking spaces may not be used for pedestrian access routes. That's no barriers in the streets. And split outdoor dining areas are not permitted. By example, having a pedestrian access route bisecting 2 outdoor dining areas. So the waiters and staff members are not crossing the establishment to serve food across the way. And no parklets or in-street dinings are permitted at this time. Also located, not that we have any, but looking forward, any establishment located within an alley that no outdoor dining shall be permitted on the public space. Most of the existing alleyways or pathways that we have are private space. And outdoor dining on public space is prohibited on the boardwalk. Again, pedestrian safety and just crowding on the boardwalk. Again, talked about the operational items, hostess stands, what have you, no tents or canopies, and outdoor dining out on neighboring properties. Talking of a fee of $500 shall accompany the application seeking a permit or supplemental permit of compliance to establish the outdoor dining on a public space. The enforcement is done by our city code enforcement officer, who will be responsible for monitoring and ensuring the compliance of the code of this policy. And then violations, if an outdoor dining license is conditional at all times. So non-compliance with approved policy shall constitute grounds for withdrawal of the license, authorizing establishments of an outdoor dining on public space. Also, an outdoor dining license may be suspended by the city manager upon finding that one or more of the conditions of this policy that we talked about have been violated. Outdoor dining is not operated in a manner that is consistent with the approved license, or the outdoor dining is not being operated in a manner which constitutes a nuisance that unduly impedes or restricts the movement of pedestrians, or that any way is detrimental to the public health, safety, or welfare of the residents of the city. Again, this language is coming from existing code that we have with regards to dining and patio dining. And the notice of suspension will be in writing, setting forth specific reasons and providing an effective date coming from the city manager. Appeals, the appeal process is the challenges to denial of a license or suspension of a license. Authorizing the establishment will be in writing to the city manager for action. And then at the end of the aspect of the summer season, the commissioners of building and licensing, we're going to develop a criteria for evaluating this outdoor dining policy on public property. And then building and licensing shall present a report to evaluate the policy at the conclusion of the season to the mayor and commissioners. So it can evaluate really what took place and what has happened over the season with this implementation of a new policy. That kind of covers those aspects of it. Talk now basically about the licensing application. And this is the process that has been in place the past 2 seasons, but now we're talking specifically on public space is licensed and issued on an annual basis. The favorable issuance of a license to establish an outdoor dining on public space is based on meeting all the criteria that we described previously in the rules and also that the mayor described in his functionality of the design of the space. And the city manager may revoke a permit for failure to maintain the compliance of the policy or the failure of the establishment to observe other city ordinances that would apply. License application is part of the evaluation. The building and license department will actually conduct a design review. As part of the application, the applicant will submit a sketch of the area, and then the building and licensing will actually go out and look at design, look at the review and review the design. I'll get it out here with the building and the licensing department to look at it actually in place and what cumulative impact it may have to that general area. If it's close to a street, if it's close to a fire hydrant, that we're all within the aspects of what we need to look at for the buffer zone, the pedestrian access route, meeting all of those criteria. And then the license will be granted where the applicant has demonstrated that the establishment primary purpose will be that of a restaurant, whether the establishment meets all of the city's applicable zoning and license provisions, whether the establishment would be a detriment to the peace, order, and quiet of the neighborhood and the city, and whether the establishment will have an adverse impact on the neighboring properties or on the city of Rehoboth Beach, considering the impact of traffic, parking, and noise. That language should be very familiar to many because that comes right out of the code again for a permit of compliance. And again, the other factors, whether the applicant has made any false representation or statements to the city, employees, or to the commissioner in order to induce or prevent action by the city, not only in regard to pertinent pending application under this policy, but also in regard to the issuance of building permit or building license. Proposed location within the state's right-of-way, because we do have some streets in the city that are under the street, DELDOT's Department of Transportation's purview. So we need, if that location has been approved by Delaware Department of Transportation in writing, and also if a state road will be altered or blocked, whether Delaware Department of Transportation has approved that proposal in writing. Again, proper access to the property for all emergency services. Proposal complies with the ADA. A fee of $500 shall accompany the application, and the license will be valid April 1 through October 15 for the year that it is issued. Also talk about in order to apply, the applicant must have a current city-issued business license. They also must have an approved permit of compliance for their indoor food service operation if they're serving alcohol. And if possessing the valid Delaware ABCC license, must abide by all the existing rules and regulations for the service of alcohol as directed by the Delaware Office of the Beverage Control Commissioner. And then again, this is acted upon restaurants using dining areas for public space must meet all the codes and regulations, the city, state, federal agencies, etc. ADA comes into play again. And all applications for the outdoor dining area on the public space received from the establishments with liquor licenses. Once the city approves this, as been the process in the past 2 years, the city then will provide this application to the ABCC for their approval. So it's a 2-step process, just how it has been for the past 2 years. And for restaurants that are serving alcohol, a city outdoor dining on public space license becomes effective only upon the approval of that state licensing of ABCC. So they have to apply to us, we forward that license to the state, they approve it, and then we, the city, will issue the license. And again, this is technical language here, but it covers the insurance requirements that are necessary, that are currently in place for all restaurants that operate both indoor and patio dining, with a complete waiver, valid waiver of indemnification agreement. And that kind of covers, I know that's a lot, but most of that language coming from existing code that we have existing in the restaurant code and also in our patio dining ordinance. So I will stop sharing right now and we'll go into comments.
Thank you, Commissioner. It seems very clear to me. I know there's a lot of details there, but if you recall in this agenda, we embedded the two presentations made on March 1st, and those were the original presentations. Of course, after today's meeting, we will embed today's condensed presentations into the agenda so everybody can take a look at them. I just also want to remind everybody that this is meeting number 2. Meeting number 1 was March 1st. Less than a week later, we're entertaining meeting number 2. The third meeting I have scheduled for March 15th at 9 in the morning, a special meeting specifically to focus on outdoor dining. And then if needed, March 18th at our regular meeting, we can continue to discuss about this. And maybe by then we'll be ready to have a vote on something. Again, we did not address some of the comments made by commissioners at the last meeting, but instead offer for you to bring those up now so that we can have, if you agree to bring them forward again, then we will have continued additional discussion on the individual topics before we get to members of the public. So we want to try to handle some questions one at a time. Commissioner Chrzanowski, please.
Patrick, did you say that no split seating, meaning that they're essentially servers cannot cross over a walkway to go to a dining section? Is that, or
Yeah,
you can't have both?
That is correct, that the tables must be placed against the facade. And that really comes from the survey that the Chamber of Commerce had taken, stating that they did not want split dining, that there was problems with servers crossing an active sidewalk.
I understood, but that eliminates a lot of businesses from doing this. I mean, there's many bump outs and buffer areas where the only option some businesses would have is to go on the far side of the sidewalk. So I just want to recognize that we're eliminating the ability for some businesses to have this by having that in the as a requirement.
Thank you, Commissioner. Commissioner Commissioner Bennett.
Yes, thank you, Mayor. I agree with Commissioner Chrzanowski about the split dining. I think we should take another look at that because I do think it does eliminate some restaurants that would want to participate. The other question I have is regarding the dates of April 1 through October 15th. Is there any particular reason why we just don't say it's a yearly application? I mean, today, for instance, would be a great day to eat outside. So, and we know into October, November, that we could also have nice days. And I think we should not be so stringent with dates. Is there any particular reason why we are? Thank you.
I think that, that certainly can be considered. One of the aspects of that was crowds with sewage. But I think we can certainly take a look at the dates and move there for further discussion.
Well, the goal is to identify everything we want to resolve. I was hoping we could resolve some today through discussion, but we do have, I would say we would need to resolve these by meeting number 3 on March 15th. So if we want to just identify what we want to bring up later and offer that to get more feedback from the restaurants and the public, then we can work it that way. I'll go to Commissioner Sharp and then back to Commissioner Chrzanowski.
Have a clarification on the practical timing of this. And I'm wondering if we are ready to go with everything we want to cover by March 15th, is it practical that we will be ready if a restaurant wanted to open this on April 1st?
Well, let's talk through the timeline real quick. One of the things that we've been pushing is the process for authorizing outdoor dining tables. One process could be, especially because some restaurants serve alcohol, some don't. But for those that don't serve alcohol, the simple permit could suffice. But for those that serve alcohol, we could codify this in Chapter 215 restaurants, create a new supplemental outdoor dining on public space permit of compliance. So that would be one option. The other option is to, for restaurants that serve alcohol, have them go under the same permit process as those that don't serve alcohol, and just adopt a resolution adopting a policy. If you recall last time, Commissioner Gossett had just in a Word document some of the part of the policy written there, and he intends to finish that. And that's what we'll likely work through at our March 15th meeting. The point of mentioning alcohol and non-alcohol in process is that if we go to codify and make amendments to Chapter 215 and then first of all, that requires time to implement. And then if we do that, then we've got to give notice to all those restaurants that want to do this to file permit of compliance applications, go in front of building and licensing to look for completeness, file and go in front of the commissioners. And you're talking about adding at least another month to the process. Whereas if we just adopt the resolution to agree to a policy and put that into effect at least the first year, then that to me helps expedite the process there. So that's one thing. But let's talk through the entire timeline, because Commissioner Sharp, you mentioned, would they be able to be set up on April 1st? Again, the first part of the timeline is we need to adopt a code or a policy, and that's going to take time. I would expect that takes at least till the 18th regular meeting to be able to vote on something. Let's say I'm going the route now of they've got their permissions. The rest are authorization through a policy. The next step in my mind is the restaurants would make submittal of their permit plans. Building and licensing would be the next step. They would process the application, including conducting a site survey and the design survey that Commissioner Gossett articulated in his presentation. Then after the site survey, they would make a recommendation on whether it's approved or not. And if it's approved, if they sell alcohol, then building and licensing has to send a letter to the alcohol commissioner. Then at that point, the alcohol commissioner has to receive an application from the restaurateur as well as from the city. And then the alcohol commissioner needs their time to be able to act on the application. And then, so even to get to that point, which the next step is to be able to you've gotten both authorizations to then start setting up your outdoor dining plan, is most assuredly going to go after April 1st sometime. So the point for me is to try to accelerate this as quick as we can while being prudent in adopting all our policies. Patrick, do you have anything else? I will just add that that's to get them set up on the dining areas on the public sidewalk. Just FYI, after they're installed, they still have to be inspected by the building and licensing, and then receive periodic inspections at some point. Commissioner Gossett, do you have anything to add to that?
Just to reemphasize the fact that ABCC has a strong role in this that basically is, I won't say is out of our control, but in conversations that we've had with the commissioner, ABCC commissioner, they are also in the process of not only having Rehoboth Beach access additional outdoor dining, but many other municipalities in the state. So that could be, a bottleneck there with the state even though we are processing it as quickly as we can. With the change in the law of HB 290, they're still, the ABCC is still kind of working through applications and how they will actually interpret that of how it hits the different municipalities. So again, we can start our application process and keep it moving, but we still, those alcohol licensing aspects have to go through the state, which we really don't have any control over.
Thank you, Commissioner. Commissioner Sharp again, and then Commissioner Chrzanowski.
I just had the reason I asked the question the way I did was exactly to surface the expectation, because the only comments I've gotten from the public are around when can it begin, because they're anxious to have this begin. But I think we need to set the expectation that my goal is that we come out of this with something extremely straightforward, simple, and speedy to get moving for the things that are in our control, and to make sure we don't have any bottlenecks at our city hall because we may have to adjust the volume that might be coming in. So I think for me, I would like to do whatever we need to do to be simple, straightforward, and speedy on our part.
Thank you, Commissioner. Commissioner Chrzanowski.
Thank you, Mayor. Again, I just want to stress that to Commissioner Sharp's point, this isn't simple. It's not easy. We're making it incredibly difficult for this to work. We shouldn't have dates. It makes absolutely no sense to have dates on this. We shouldn't have anything that prohibits split dining in terms of walking across a pedestrian way to be able to have dining tables. It is incredibly unfair that we have the 750 square foot prohibition. It's just completely unfair that we would have that prohibition. And the application fee of $500 is pretty steep. And we shouldn't have an application fee. We should have an extension of premises license, so that people are only paying a fee if they actually are able to have the outdoor dining, not an application fee. That's unfair as well. So those are my thoughts.
Thank you, Commissioner. Commissioner Gay.
Yeah, first of all, I just want to agree with everything that Commissioner Sharp said about the importance of the timing of this. Correct me if I'm wrong. If we don't adopt a policy by March 31st, it all goes away, right? They can't do anything. Is that right?
That is correct, because of the governor's emergency order. That is the reason why it is out of. We have to do something.
Right, exactly. And I had stated at the last meeting that I want to have permanent outdoor dining, and I do. But it sounds like this is a step toward that, and I'm certainly willing to accept a step toward that while we work out all of the details. But as I said, I agree with Commissioner Sharp that we need a plan that we can act on in order not to hold these restaurants up from being able to go into operation as soon as possible.
Anybody else before we go to the public? Thank you very much. Let's go to the members of the public. Kate Wall, you were not on earlier. I don't. Kate Wall is of Shorebreak Lodge. She's not on. Walter Brittingham.
Pass.
Thank you, Walter. Melissa, are you there from Egg Restaurant?
I am.
Here's your opportunity.
Okay, thank you, Mayor and Commissioners and all, for this opportunity. You answered a lot of the questions. I want to say I understand and agree and appreciate the rules and policies on the public spaces. It makes sense to me. Currently at Egg, we comply with all of these rules and policies. My question is, we are on private property. So I'm wondering, is this 750 square foot rule going to apply to us, or do we, you may have answered the question, are we just going to simply have to apply for a permit of compliance to continue with our outdoor cafe? The other thing, this is, I'm just in what you just were saying about the March 31st, this goes away. And I might be speaking out of turn. I am really ignorant when it comes to politics, but from what I hear from the bigger wigs in the restaurant industry, the Sodells, et cetera, they say that there is a bill to extend this, and that may help if he does sign that. I was told through the grapevine that he may sign this bill, and that will extend the outdoor dining permission and may help with this. You're all trying so hard to expedite this. It may give you time to then, if the governor does sign this bill, we now can get open April 1, and then you have time to implement your rules and look at things more individually as far as public dining and situations with egg and others where we have private property dining. This way it will buy you the time we can then have the time to apply without bottlenecks in the city, et cetera, the ABC. So those are my questions and concerns.
Thank you, Melissa. I will respond to your one note about can you make application for permitted compliance for outdoor dining on private space? The answer is no. Currently, our Chapter 215 codes and permanent compliance process does not allow for any restaurant dining patio seating on property other than the licensed property. Glenn, is that correct? Patrick?
Right, Mayor, just for clarity, as you said, Chapter 215 and our zoning code work together as to regulation of private properties. So any outdoor dining on private property is covered by the supplemental permit of compliance process that allows up to 750 square feet on private property. So to the extent you want to maintain outdoor dining on private property, the process to follow is outlined in Chapter 215, the supplemental permit of compliance process. What the commissioners are discussing today is as to outdoor dining on public property and the process that will be pursued for that sort of an operation. It's two different avenues for outdoor dining, one for private property, one for public property. And also, I guess I can address, I think perhaps she was mentioning House Bill 290. That is a bill that was intended and has been passed. It was intended to streamline the process at the ABC Commissioner's Office so that those who have outdoor dining on public space, the commissioner cannot view that space as a substantial change. If it was viewed as a substantial change, there'd be a public hearing process and everything else to allow it to continue. So at the ABC commissioners level, there's some streamlining that has happened through House Bill 290, but that does not affect local zoning regulation. And that's what you're trying to deal with, is how do you locally authorize dining on public property, separate from House Bill 290.
Thank you. Thank you. Anything further, Melissa?
At this point, this probably isn't the time. I'm just going to have to talk to the city about what I could possibly do to get permission to continue with part of the outdoor cafe, as we stop seating at 1 in the afternoon. We're cleaned up and out of there by 2 o'clock every day. So I understand a lot of the rules are probably in place because of evening noise levels, et cetera, where egg is unique in that we've just had 2 years experience with no problems at all with that. So I was hoping, that there's some way we can handle things on an individual basis. Otherwise, that's all I have.
All right. Thank you. Thank you, Melissa. We'll continue with members of the public. Carol Everhart, anything on the outdoor dining topic?
Yes, Mayor. First, the prior survey that we did was in October of 2020. And most of the things that you talked about showed up on this survey. One of the things that showed up that has been brought up, the logistics and safety, and that's where crossing a sidewalk to serve, there were a number of restaurants at that time that felt that that was unsafe for their wait staff. So that was the purpose behind the crossing over a sidewalk to serve. It did not have anything to do with the amount of people that they could serve. Basically, I'm going to go to the simplistic again on this. What these restaurants are saying is once they've met the requirements, whatever the licensing is, whatever the fee is, whatever the inspection is, once they've met that, they see no reason why it can't be year-round. We very often have a beautiful day when they can set that up and serve outside. So their interest is in allowing good weather. They can operate outside as long as they are within the requirements and the conditions that have been set by the city and ABC and the rest. So they're very happy that the city and the mayor and commissioners are wanting to continue the outdoor dining. I think the visitor, the resident, everybody's happy about that. But if we can keep it simple, I think it will allow us to move forward a little bit quicker.
Thank you, Carol. With that, Cindy Lovett.
Mute. There we are. Good morning, everybody. And I really want to thank you so much for taking this up and trying to move it forward quickly. I think that the one thing I've been trying to understand is the basis for the 750 square foot rule. I don't know how long it was, when it was created, and exactly why there would be a constraint at all on outdoor dining. Because certainly wherever we travel, the first thing we do is look for a restaurant that has outdoor dining. It's just how it is. I just understanding that basically the Egg Cafe, which I think just provides a beautiful entree to the city for visitors coming into town and a warm feeling, it's basically going to go away. The front porch dining is really the handicap dining. It's dining for a lot of senior citizens prefer that. And when it's really hot, it's a nice option. So it would be sad to give that up. I just would really like someone to explain to me where the 750 square foot came from, and could it be changed? Could we not change that? There's only a couple restaurants that have the private dining, so it's not as though it's going to be a major problem. And I just think any outdoor dining that we can have, and I understand certainly on public property, it's there's rules, and I think you've done a great job of explaining them. That's basically all I've got.
Thank you, Cindy. And again, for transparency, like last time, I wanted to identify you as the landlord for Egg. Thank you very much. With that, Dr. Trejos and Mike Strange, I think, have signed off. They got their topics taken care of. Is there any further discussion about from the commissioners?
Yes. I think, Mayor, and think of discussions and of this, I think that, that I would like to think through this and think that we could certainly have a license that would operate annually, from January 1 to December 31st. I think with the language that is added to the policy, the current policy that gives the city manager the ability to have the restaurants, if you will, the public dining closed down, as the phrase is, community or special events, utility, sidewalk repairs, road repairs, emergency situations. I think that was the major concern of guiding the dates, in the sense of when we do work in the streets or snows that come, or setting out of the benches or painting curb sides with yellow painting, this kind of stuff. So that work that takes place. So I think with the language that is added to the policy that gives the city manager the ability to make those changes or to restrict that dining for a certain period of time with advance notice, and also with storms that come up, hurricanes potentials, this type of thing, that language would allow us to have that capability for the protection of the city and the residents. So if we were to, say a license for outdoor dining on public property may be issued annually from January 1 to December 31, again, with the other language that allows us to have reactions or ability to react to special events, weather, those types of things would work. Thank you.
Thank you. I think what I'd like to do is to help try to advance this. What I would like to do, I'll still take any more comments today from the commissioners, but what I would like to do is highlight some of these that we've identified today as still questionable. Size of the dining areas, duration of the program, time limited versus year round, the fee, split dining, and anything else that we've come up with. And actually give us more time. Let's bring them up, put them on the agenda for May 15th. And let's actually conduct a vote on those individual items so that we can resolve them. And then that way we'll be ready to move forward to hopefully a final vote at our regular meeting of December 8th, March 18th. Any further comments?
Just one, and I guess, Glenn, you may give some comment on this, though, but the discussion of the 750 square feet, that's currently in our zoning code, correct?
That's currently in the zoning code, and I'm trying to recall exactly why it was 750 square feet. This is years ago, the commissioners had discussion about what size made sense from a noise perspective and other things for outdoor dining. Some of our outdoor dining in the commercial district abuts the residential district. So I know there were those sorts of concerns, but yeah, but that's right. Existing code is 750 square feet for outdoor dining.
But what that does mean though is if we avoided that, we could, in this particular policy, I believe we could say outdoor dining on public space either has size restrictions or doesn't. And that could be separate than the 750 square foot limit established in 270-19.
That's right, Mayor.
I would agree but that 750 is in the zoning code, which then would take a longer process, isn't that, with setting a hearing, having a public hearing, et cetera. So that would really delay the process, correct? I mean, it could be addressed at some point in the future, but currently that would certainly slow down the process.
Well, I think the mayor's comment is that, I don't mean to put words in your mouth, Mayor, but I think your comment is that the 750 square feet is only outdoor dining on private property is subjected to the 750 square feet. So you could do something different for public property, and you wouldn't be held to the 750 square feet for private property.
By example, we could say outdoor dining on public space has a limit of X hundred square feet, and that would be adopted as part of this policy. So we don't have to go back to the zoning code for that. All right. Commissioner Chrzanowski, Bennett, and Gay. Commissioner Chrzanowski.
Yeah, thank you, Mayor. Yeah, the 750 is irrespective of this, and the only reason why it's referenced is because you referenced it. Essentially, someone that has a patio of 750 square feet on private property is not allowed to have sidewalk dining in public space the way that you wrote it. But that there's no reason for that. That could very easily be taken out, or we can say, you can't have 750 square feet of public dining space or dining space on public property. So it sounds to me as though Commissioner Gossett has agreed that we shouldn't have dates associated with this. It can be a year-round license. So I think that's one step moving forward. But we've not, there's a few other items that we really haven't gotten input from commissioners on to move this forward.
Well, they need to be identified or they're going to be overlooked. But the goal is to identify everything and put it on the table for the next week. And then we need to step up to the plate and make our feelings known. And if we have to conduct a vote, then that's probably the best way to do it. Commissioner Bennett.
Yes, just for clarification, because as I read both the presentations, I too am confused about this 750 square foot, whether that was just public or it's public/private, which we weren't initially discussing. But I am wondering, as this is written, would this mean that egg would not be able to be outside?
Would not be able to be outside on the neighbor's property, correct?
Right, and because I think that would be a bad decision. I think there's nothing nicer than coming into town and seeing all those people outside, and it's a very warm, welcoming feeling to the town. And I think that would not be the way to go. So I would not be supportive of that. Thank you.
Thank you. Commissioner Gay?
Yeah, first of all, I want to say I can certainly support the year-round licensing and the year-round possibilities of outdoor dining. I can see the advantages to that. In terms of the split dining, I guess I'm a little confused by that because I feel like if a restaurant, and I'm not even thinking that there are very many examples of this, so it's hard to picture in a way, but if a restaurant has enough room for split dining, then they clearly have enough room for dining against the facade, and that's really what we're trying to do here, is make that possible so that the pedestrian pathways are clear, and as Carol Everhart said, that the safety of the the wait staff not going across pedestrian paths. So I feel like I'm okay without having split dining for all those reasons, because I don't think it must not hinder a restaurant from having dining against the facade, because if they've got room for split, then they've got room on the sidewalk. So that's one thing. In terms of I don't know what square footage we might come up with in the policy, and I certainly take the point, and I'm glad to hear that we could have a separate, number in the policy than we have in the zoning code, because it's going to be time consuming to go back and revisit codes. I don't know what the ideal number is, but I also feel like it's pretty self-limited. I mean, if you're only talking about the front facade of a restaurant, and you're only talking about a certain number of feet out based on the other metrics that you proposed, it's going to be pretty limited anyway. So maybe we have to state what that number is. I don't know.
All right. Thank you. Thank you. Again, we'll come up with some, Patrick, if you'd be the liaison and help write down any questions that came out of today's meeting, so that we can maybe perhaps offer some different scenarios for the next meeting and offer analysis so we can put them to a vote and resolve them. We've got Commissioner Chrzanowski and then Commissioner Sharp.
Thanks, Mayor. Just to follow up Commissioner Gay's comments, just the way that some of the sidewalks are configured, it's just not possible for some restaurants to have tables against the facade. I'll give one example. Go Fish was not able to have tables against the facade when we did outdoor dining for the pandemic. They had to utilize one of the bump out spaces on the other side of the sidewalk. It's just the way that some of the sidewalks are configured with bump outs and what makes the most sense for pedestrian walkways. And I just also want to note that when the chamber did the survey related to some of these topics, some of that was preferential. Would we rather have the pedestrian, and it had to do with taking away, using the sidewalk space rather than using the parking spaces and where the pedestrian walkway would be. So some of those comments were, what did they prefer? Did they prefer having tables on the sidewalk and using the parking spaces as a walkway, or vice versa? So I just take that with the intent. It was what was preferred, not what was impossible or not possible. So I just want to make sure that that's clear. Thank you.
Commissioner Sharp?
I just need a quick clarification for my own thinking as we move toward March 15th. If we take up any issue that is connected to a zoning change, does that not trigger, or I'm under the impression it triggers more delays because of the timing necessary to alter zoning? Am I correct about that?
Glenn, you can help. I would say, yes, you're correct, but because we're approaching this in a policy form, I don't see that anything proposed within the policy has to do with zoning. Glenn?
Okay, that's the nugget. The way the mayor just stated it, Glenn, that's the nugget that I need just a little more clarity on, please.
That's right. So remember, zoning laws regulate private property. So what we're talking about here is the use of your city property. You as commissioners own that property, can do with it as you want. Now, if you're going to affect somebody's rights as to their private property, they're owed a lot more due process. So you're going to see public hearing process and all that. So in this instance, since you're only dealing with public property, it doesn't trigger all those hearing requirements. But if you touch, but you're right, Commissioner, if you touch anything in zoning, it's going to trigger those public hearing processes.
Yeah, and it's very self-serving on my part because I don't want to touch anything that triggers additional delays because April the 1st is just a few days away.
Right.
Thank you.
Thank you, Commissioner. Any, Commissioner Chrzanowski?
Yeah, sorry, Mayor, just for the record, and no one wanted to say this, but essentially there is no path forward for Egg and Melissa. And I think that's a shame. And I don't want to hold up this process. Dining in public space, I think we're on the right track. We need to move forward and there should be no delays. But we need to revisit dining on private property and the rules surrounding that. The fact that Melissa and Egg cannot move forward, continuing to operate the way they have the past 2 years is a shame. And the fact that we're not talking about that and putting forward a path forward for that to continue is a problem. And I would like that to be one of our next meeting topics is how do we continue that on private property? So I just want to say that for the record.
Well, thank you, Commissioner. All commissioners, I guess I caution us on saying too much more about Ag because they're in front of us tomorrow for permit compliance. But Commissioner Chrzanowski, I don't disagree with you that let's not hold this up. Let's put it on a future agenda for additional discussion. Anybody else? Patrick,
Well, I'm sorry.
go ahead.
I can't remain silent. I know it's not on our agenda today, but I would hate to for me personally, I'd hate to walk away from this meeting thinking that there is no potential relief for any restaurant that might get us through some kind of action, and that would certainly be Glenn's territory and yours, Mayor, some kind of action that rather than we have a hard and fast dismissal of something, is there a further discussion that can take place that has any potential for any kind of relief? I don't know, but I think we could certainly think about that. That's all. Thank you.
We can entertain that. Thank you, Commissioner. If there's no further commissioner comments, I think we have our path forward. The next meeting on this will be outdoor dining meeting, special meeting number 3, March 15th at 9 o'clock in the morning. Patrick, you've got some marching orders to help identify some of the questions and concerns here, and we'll come up with some further analyses and options and present those at the next meeting so that we can all try to move forward to finalizing some of these things. Looks like Dr. Trejos is back on, so let's, before we adjourn, let's seek his input. Dr. Trejos, you there?
Yes, Mayor Mills, can you hear me this time?
We can this time.
Oh,
Yes, sir.
very good. I don't know exactly what was happening the last time, but I had to log out and log back in. And again, thank you so very much for allowing me just to briefly speak. Let me just notate a comment that Michael Strange eloquently stated. And
I'm sorry, Doctor, are you going back to wireless? Because
yes, because I'm sorry. Is there an opportunity to do that? If not, then that's not a problem.
Glenn, are we okay?
You can go back to it, Mayor, unless you want to hold it to the end. But if he's on now and you're willing to entertain it, there's no problem.
Go ahead, Dr. Trejos. We switched to dining, but go ahead and present
Thank you very much, Mayor. And yes, I mean, I do support, first off, I do support the dining, outdoor dining, and I'll leave it to you all to determine the details. But more importantly, just to briefly state that, and again, I want to dovetail Michael Strange's comments, and he made some eloquent comments regarding that. Just to notate that in the proposal that was written by CTC, seconded paragraphs lines 102 through 106. Again, I just want to make the notation that that paragraph, though complying with the FCC, deals strictly with aesthetics. Again, I just wanted to reiterate that BETA, best available technology, economically achievable, is just that. We're talking about technology, not necessarily aesthetics. And it becomes important that whenever wireless telecommunications companies put up facilities, they use the best available technology, economically achievable versus merely economically available. By utilizing the best economically achievable technology, you're going to actually, on a side note, improve the aesthetics. I had made that comment early in a previous meeting, as did Michael Strange. So again, I just wanted to reiterate that lines 102 through 106 deal merely with aesthetics and do not deal with the technology to improve to achieve improved aesthetics. So this is just a point of a notation and of interest. And again, thank you, Mayor. I appreciate it. And again, as I had sent a note to everyone, it's been an honor and a privilege to be able to have spoken to you all over the past 2 years. And since you were no longer going virtual, you won't be hearing from me pretty much in the future, but I hope to be around and submit written comments. Thank you so much. Take care. Bye-bye.
Thank you, Doctor. You've always got email.
Mayor, you're muted. Mayor, you're muted.
Here he is.
How about now? There we go. Thank you, Dr. Trejos. We appreciate it. And as always, you've got email available to you as we welcome your input as usual. Are there any further comments before we move on outdoor policy? Again, we've got our path forward. I thank you all for your input. And I wanted to thank members of the public for your input. Also, we are still taking input from now till we vote. So please share any further comments by talking with us individually or in writing. With that, we'll go to the next item of business, which is to discuss chair position for the Stormwater Utility Task Force. Since that committee went from originally intended 5 to 7 to 13, and based on some of our committee rules about commissioners chairing, I decided the more prudent thing would be to have a commissioner chair it. I originally offered, but so did Commissioner Legree. So I would welcome my nomination of him to chair it at the March 18th meeting and have you all vote for it. Do you all have any further discussion of this topic? That should be a good.
All right. The only question is, and maybe this would be during the vote, but have we determined the role of the facilitator in this task force?
Yeah, and Kevin, we can forward an outline you might have on that?
We certainly can when we get it prepared.
All right. All right. Sounds good. So yeah, we'll share what we can next meeting. Anybody else? Commissioner Sharp?
Just, I think Jail Agree would be just a terrific choice.
Very good, thank you. With that, we'll go to the next item of business, which is to discuss nomination to fill a vacancy on the unexpired term of John Dewey on the Street and Transportation Committee. Chair Ed Chrzanowski. Unmute. Share your nominee with us, please.
Yeah, thanks, Mayor. I nominate Elise Moore. She is one of the owners of the Admiral Hotel on Baltimore Avenue. Been around in the city for a long time, owning various property and businesses. And she currently is already on the Streetscape, Baltimore-Wilmington Streetscape Task Force. So she's familiar with that project. So that's my nominee.
Very good.
We do have an additional vacancy on that committee as well. Hopefully nominating an additional person in the next few weeks.
Sounds good. Thank you very much. Commissioner Sharp?
I just have a curiosity because I honestly don't know how many business owners do we have on streets and transportation?
None.
Oh, this is good.
None, yeah.
Thank you.
Thank you. With that, are there any members of the public that want to comment on membership on both those committees? We've got candidate Walter.
Pass.
That's Carol Everhart. Cindy Lovett.
She's no longer on the call.
Dr. Trejos, I assume you're done. If not, speak up. Thank you very much, members of the public. With that, we're going to go to the next item of new business, which is update on the new lead and copper rule recently promulgated by the EPA and impacts of the new rule on the city's water department operations. Sharon?
Thank you, Mayor. I think we're turning this over.
Good.
Turning it over to Mr. Williams.
Thanks, Sharon. Thank you, Mayor. I just wanted to provide some update to the lead and copper rule, which was changed and promulgated into law, I guess, at the end of last calendar year, so in December. So I just want to touch on that, just to give you an update as to where that is and what we're doing here in order to maintain compliance with the lead and copper rule. And first thing I want to say is we do not have a lead problem in Rehoboth in our drinking water system. So that's got to be the takeaway from today. Is I don't want to see, anybody going with their hair on fire about, we've got lead in our drinking water. We do not. So I just want to start with that. But there are some things that the new law will require us to do that we're not currently doing, and will result in quite a bit of effort required of our water department. So here's just a snapshot of the agenda I plan to follow today. The original rule came into effect back in 1981, and it basically set up testing requirements, sampling and testing requirements based upon the size of your water system. And we're a relatively small system, so we had different regulations than some of the larger systems would be required to have. And it set up action level at 15 parts per billion. And if you're familiar at all with lead and copper rule, it's not as simple as just going to a house, and if a house has more than 15 parts per billion, then your system has problems. It's based on what they call a 90th percentile, and roughly that's if 10% of your customers exceed the action level, then the system exceeds the action level. And you can imagine some of the problems that causes. You could have 10% or 9% of your homes that widely exceed the lead and copper standard, yet your system would be okay and you not really have to do much. And a lot of that came to light, back in early 2000s when I think one of the first issues of lead problems arose in the Washington, D.C. area, and we'll talk a little bit about that here in a few minutes. Lead typically has the most serious impact on young children and pregnant women. It affects the development of the brain. And you remember the horror stories of little kids eating paint chips with lead and the lead gas and the fumes and the residue and dirt that they're playing and all those kind of things. So it was really revolved around trying to protect children, both born and unborn, to keep them away from the dangers of lead. So the sources of lead in drinking water can be several things. One is you have a lead pipe itself. Another one would be if you have a galvanized pipe which had been previously, is currently or had been previously attached to a lead pipe. Because as most of you know, the galvanized pipe corrodes very easily, and it would get these pits and chunks in it that would be able to capture and retain lead particles if they became broken loose from the lead pipe. They could catch in the galvanized and could be released later on, even though you thought you had no lead. If you had lead prior, it could still result in a problem. You can also have it in internal plumbing fixtures, which is an issue. Even your non-lead fixtures contain some lead. So that is another issue that this really doesn't attack. It's really looking at the service lines, this particular rule. And then finally, it can also be in any lead solder. So if you had copper pipes or some other type of metal that had been soldered with lead solder, then you could also have that leach into the drinking water and cause problems with your drinking water. In Rehoboth, our system, we have about 6,000 customers. So we would classify as a small system. We're required to test for lead and copper in accordance with lead and copper rule every 3 years. And we treat our water at the treatment plant with orthophosphate chemical, similar to what's in Cokes and soda pops that help coat the inside of a aluminum can, so it keeps the can from corroding from the acid in the soda. So it's commonly used. That's what we use to coat it coats the insides of the pipe, keeps the lead in the lead, and keeps the lead, kind of coats the inside, so it's a little smoother. It doesn't cause the corrosion types of things. And our most recent test results, which were, I think, a year and a half, 2 years ago, reminder the action level is 15 parts per billion. We were at 0.9 parts per billion, so well under the requirements with respect to that. Just a little bit on the new rule. So go back just a little. So again, the original rule was promulgated in 1991, and since 2004, the EPA has been trying to update the rule. Again, mainly around the issues that were discovered in Washington, D.C. in the early 2000s when they had their crisis and were trying to mitigate some things. It came to light that some of the things in the existing rule could be reworked. But as with anything coming from the EPA, it took a long time to do. So we're now 2022, some 18, 20 years later, and we're finally getting a revised rule. The revised rule becomes effective October 2024. So you say, okay, why are we messing with it now? But there are a lot of things that have to be completed prior to the implementation date, and we'll talk about some of those things today. The big one is, or one of the biggest ones is the inventory. So we're working to get the inventory completed where everyone knows what is or isn't in a particular lead service line. And then I'll talk a little bit on the next couple slides about the major changes that apply as a result of the rule and how they impact our water department. There are many other smaller changes and impacts. Some of those are based around what we find in the actual inventory, but we'll leave those for another day. We'll just talk about kind of the major ones today. First off is the requirement to perform a lead service line or a service line inventory, and that's here we go. It's extensive, as you can imagine. If we've got 6,000 customers, trying to determine what each of the segments of a particular service line are, can be fairly problematic. But just in general, the schematic on your screen kind of shows the typical layout or configuration of a service connection here in Rehoboth Beach. So it starts, at the water main is in the street, usually buried under the street. It's then got some sort of connector, then the service line that runs from the main to the meter. Then you have the water meter itself, and then another service line that runs, or a continuation of the service line that runs from the meter into the property itself. So each of those segments can be a different material type. And typically what we see in Rehoboth is at the water main, the connection at the water main is a lead gooseneck. So that's about a 3-foot section of lead. They used it because it is somewhat flexible, so you could bend it. So, not like another metal that would be very rigid, that would crimp or could get damaged during the installation. So it's very common that they use this gooseneck of lead, then connect to a service line. And that material could be lead, it could be galvanized, could be copper, could be what we typically use as plastic, or in many cases, it'll be a material that we don't really know. It becomes difficult when you have galvanized downstream from the lead, because then obviously the lead, even though it's a small section of lead, could impact what's remaining in the galvanized downstream of the lead as you work through the issues of removing as much of lead as possible. In this particular case, if you can kind of see my cursor, the entire service line in Rehoboth is owned by the homeowner. He's responsible for that entire service line, even the part that is in public space. Many places you'll see that the responsibility breaks at the property line. That is not the case here. So in a case where we have a water leak now, like down in section 2, the city will go in and repair that, and we send the bill to the homeowner for that repair. If it happens out in section 5, it's purely the homeowner's responsibility, and they hire a plumber and they come out and fix it on their own. This will get a little tricky when we talk through replacing these service lines, but just want to make you aware that right now the city code stipulates that all this belongs to the homeowner to operate and maintain. Again, it'll get a little more discussion when we talk about full replacements versus partial replacements, and just from a definition perspective, a partial replacement would be as if there's a leak in section 2 and the city comes out and we repair this and don't do anything on the homeowner side of the meter. That would be a partial replacement. Or if you came in and just took a chunk out and spliced it, again, that's a partial replacement. A full replacement would be you would take everything from the main all the way into the house and replace that, and that is a full replacement. In Rehoboth, I think I mentioned earlier maybe that the typical installation in Rehoboth, this is all 1-inch polyethylene pipe, so plastic. That's our standard in Rehoboth. Another important thing about the service line inventory is that the new rule requires us to make that readily available to the public. So again, depending upon your utility size, it could be as robust as being a web-based interactive system where you could puck on an individual address and it'll drop down and tell you, each of the material types and the various segments of the service line. And that could be both homeowner and public. So if somebody's just interested or somebody wants to buy a property, they could get on there and see what the service line materials are made from. For smaller systems, it could be as simple as putting a spreadsheet out there. So we had an intern with us last summer who we put on the preliminary work for conducting our service line inventory. And we have determined that the city has about 1,500 lead goosenecks. We talked a little bit earlier about what the gooseneck is, that little 3-foot connection. So in a case where you have that lead gooseneck and no other lead in the line, it can be anything else but other than lead, those are not classified under the new rule as a lead service line. So you don't have to report them as a lead service line, but you do have to treat them as a lead service line if you would do anything to them. If you're going to repair a leak, replace a meter, replace a service line, whatever, you have to treat it as though it was a lead service replacement. And we'll talk about that in a few minutes with respect to the replacing of service lines. So this inventory has to be completed, posted, accessible to the public by the implementation date in October of 2024. The other tricky thing with this is we have pretty good records of what has transpired within the public space. So we have the as-built drawings from a lot of the system. We've done a lot of work, recently in the system with water main replacements and meter replacements and the like. And with those, we have a pretty good record, but we really only track it up to the meter itself. We don't have a good handle on what happens from the meter to the property. So one of the things we have to do is go do a physical inspection or try to do a physical inspection of the service line material between the meter and the property line. So here in Rehoboth, it basically is two things. One, you either dig up the front yard on the private property side of the meter, or you get permission to go inside the house into the crawl space or wherever the service line enters the house and see what the material type is there, and then you can determine what the material type is for the inventory. So as you can imagine, that's going to take us quite a bit of effort. Certainly the easier and quicker way is to get in and take a look at it, but that then necessitates agreements from homeowners to let you in, get into the crawl space, and actually do that inventory. So that's one of the things we're going to be approaching here pretty soon, just because we know how long it's going to take to do that complete inventory. So the inventory is the first thing, and that's going to cause us a lot of time and effort to put that inventory together and get it properly accessible. Second is the sampling and the testing program. Some of you have actually participated in our lead sampling program in past years, because I know that one of the things we typically do is try to go commissioners' homes just to compare that to sitting commissioners, so because we can kind of control how the test is performed. It's a very unscientific methodology for taking the test. You have to has to sit dormant for 6 hours, and so the first draw in the morning has to be into the 1 liter bottle. So you can't get up, hit the restroom first, and then go down and draw the sample. You got to get up, go down, draw the sample, and then do whatever else you're going to do. So you can see in this picture here, currently, the only sample that is drawn is that first draw 1 liter bottle sample. And then it would be sent off to the lab, evaluated, and then you would take any actions based upon what the results, if you had high results in those, your 90th percentile, based upon the number of samples you've done. So the new system is going to be to draw actually 5 1 liter samples. So you hit the first one, and then 4 subsequent ones. And what that enables us to do is actually get water out of the service line. So if the first draw 1 liter sample is really just getting water that's already sitting in your house. And that may show you a lot to do with what your internal plumbing might have, but it really doesn't give you an indication of any lead that might be getting into your water as a result of the sitting in a service line that has any kind of lead or old galvanized pipe that had been connected to lead. So the new system will take all of these into account, and you'll actually test all 5 of those samples. The other thing it does in the new rule is it establishes a new level called the trigger level, which is significantly lower than the action level. So you can see one was 15, and now the new trigger level is 10. So if you hit the trigger level with your annual sampling, then that necessitates the development of a mandatory replacement program. And that is where you and the regulators get together and figure out what's a reasonable number of these lines that you're able to replace in any given year. And for those that have some tie to the DC area, you'll recall that I think they were required to remove 4,000 or 5,000 lead service lines from their inventory every year. So it can get quite drawn out, quite expensive, and quite time consuming. The other thing they've enhanced quite a bit is just the whole notification process, who you have to tell and when something like this happens. So, and the most notable one is if you have an exceedance, you have an immediate requirement to immediately notify your customers, much more like you would do if you had an E. coli breakout or something of that nature in your system. Prior to this, you had, I think, 72 hours or some extended period of time where you could actually get the word out to that you had an exceedance, but it definitely shortens the time of being able to get the word out to the public if you do have an issue. And because of the impact that lead has on the formation of the brain in children, small children, and pregnant women, they've added specific guidance with respect to testing at schools and daycare facilities. We've identified 5 within our service area. One of those is the new Rehoboth Elementary, so it's exempt because of when it was constructed. But the other 4 require additional sampling above and beyond what they would have had to do under the current law. And it's not onerous for us because we have such a small number that we would probably just do each of those daycares annually just to be on the safe side. Now, the final major change for us, and this is probably the biggest change for us and biggest impact to us, is the replacement of a lead service line. So I mentioned that our particular lines do not classify by the new rule as a lead service line because it's only the lead gooseneck and none of the service line itself that has lead in it. But I did say that if we do anything with it, then we have to treat it as such. And they set out specific requirements for what has to happen in the event that you have to do a replacement of any type. So again, if I go back to our leak example, where if there's a leak in a water system, we go out, we dig it up, we repair the service line somewhere, either on our side or on a private side, either one, then it triggers the requirement to do certain amounts of flushing that we would do as a contractor or the guy doing the work, and then some other instructions that we would give to the homeowner that they would flush a certain amount of time over a period of time in order to flush out anything that would break loose as a result of the work. What has been found out over the years is that when you go in and do anything to a lead service line, it causes the lead concentration in the water to go up because it actually dislodges lead particles and gets it out. So even after a partial replacement, the lead levels go up considerably. And it takes about 4 months normal usage to bring that back down to below the action level after a partial replacement. So the communications piece and what is provided to the homeowners that they need to do to help mitigate that is pretty extensive. So we'll start working on those, getting the notifications out, that at least have it prepared so that when we do encounter one with something like a leak, that we're able to give those instructions to the homeowners. And the other thing that we have to do after we do any work on a service line is we have to provide that individual with a pitcher filter and 6 months worth of filter cartridges so that they can use that as their drinking water source and not take it out of the tap, but to provide that pitcher filter and cartridges to the homeowners. That is proving somewhat difficult so far as we're trying to track down, the pitcher filters themselves. So you can go to Rite Aid or Walmart or something and buy 1s and 2s, but you can imagine we're trying to buy a couple hundred each year, and we're competing with DC and Newark and Pittsburgh and all these other places that are buying tens of thousands of these at any given time. And then you couple that with the plastic issue with respect to COVID and the lack of a lot of things that are made of plastic or the toughness of getting those. We're kind of working through that on trying to figure out how we get our hands on the number of pitcher filters that we think we're going to need for any replacements that we might do. And then the third thing it does is a third major thing is directs us to go back and resample that particular residence or building within 3 to 6 months after the replacement. So even though it's not a lead service line replacement, or it's not a lead service line that we have, it becomes one as soon as we go and touch it and doing work on it, and we have to treat it like it was. So the question of why now, I think I touched a little bit on it. Doesn't come effective until 2024, but there are a lot of things that need to get started on immediately. We started the inventory piece already. We've got to start creating and putting together our outreach stuff that we're going to need for the various pieces of literature we're going to hand out to folks. There are a couple of probable code changes we may want to entertain and talk about doing. And then the other thing is we're currently pursuing external funding sources So I didn't want the first time that you see anything about the new lead and copper rule to be when I come to you to ask for a letter of support for whatever monies we're coming back and trying to pursue. So we are actively doing that now. So I wanted to get this out to everyone just to kind of understand what's going on behind the scenes with respect to the lead and copper rule program. So here are a couple of things that we need to just be thinking about. The whole idea of the service line ownership, that becomes a little tricky, right? If we're going to do a water main replacement, and like we just did this year on Maryland and Olive. So if we do a water main replacement, right now we, the city, pays for the service line replacement all the way to the meter. I don't know whether we should be or not. I mean, that's just the way we're doing it. But if you look at the code and it says that the homeowner is responsible all the way to the main, then we may want to look at possibly modifying that or changing the way we do business, either one. Another thing we might want to look at is respect to a new home or a major reconstruction. Right now, a lot of times they just go to the existing meter. So if they don't have to dig up where the meter is now and relocate it or whatever, they just go to there. That doesn't do anything with respect to getting the lead out of the system. So we may want to look at requiring a major reconstruction or new construction to actually run a new service line all the way to the main, do a new tap, get that lead out of the system. We talked a little bit about the customer outreach materials that we're going to spend a little time doing. The access, we talked about the private side access to be able to complete the inventory is going to be an issue. And then one thing that we've talked about internal to the department is that if we can get the materials we need to implement some of these reducing things like the filters and the flushing guidance, we can get that prepared. There's no real reason to wait until 2024 to start doing that, so that we would look to try to implement that. In fact, we would really like to implement it with our upcoming water main replacements, in this current fiscal year. So if we do one, we would start those obviously after the season. So October, November, we'd do whatever water main we're going to do. We would hope to have the materials in place to at least be able to do the mitigation measures for those water mains this year. And in summary, we do not have a lead problem in our drinking water. I can't say that loud enough or enough, right? We do not. Our levels are extremely low. We don't have any true lead service lines that would be considered lead service lines under the new rule. We have a lot of lead goosenecks connected to other service line materials. So we do not have a lead problem in our drinking water, but as I say there, we have a lot to do in order to get ready to stay in compliance with the new lead and copper rule when it becomes totally effective in 2024. And with that, I'd be happy to answer any questions you might have.
Great job, Kevin. Thank you for paying attention to this and being on top of it. It's certainly beneficial. Thank you.
You're muted.
You're good. Thank you for monitoring my lips. Appreciate it. Any commissioner comments? I thought this was very useful, very interesting. I know it's on the minds of other municipalities also. I do want to sit with you, the city manager, Kevin, and talk about perhaps putting on a future agenda some of these possible code changes, and we'll go from there. Commissioner Gossett?
Yes, thank you for the presentation. Just curious of the public accessibility aspect you talked about, even just a spreadsheet. Do you know if Munis has the capability of producing this kind of information for public access?
I personally don't know. I would assume so. It's a pretty comprehensive package of software package, so it may very well be able to do that.
If you could confirm that one way or the other, I'd appreciate it. Also, is this affected all customers, not just commercial and residential, but all customers?
Yes, Commissioner, that's correct. All customers.
And are our current mains in the city cast iron and poly, or they didn't make any lead mains, correct?
That's correct. We really don't find lead pipe much larger than 1 inch, certainly not any larger than 2 inch, just because the size and weight of the line, the wall, pipe wall itself would just be immense. So we don't see any of that in the larger solid pipes. Typically in Rehoboth, we had all cast iron mains, various sizes, and then over the years, several men, I don't know many, but there have been some replacements done, and we replaced that with PVC pipe.
And in that replacement, all of those laterals were then reattached with a lead gooseneck, do you think?
No, all the PVC has a direct connection with a corporation stop. So it would go just pipe material poly to the corporation stop, which is right on the main. So there's no lead goosenecks associated with the PVC piping.
With any of the ones the water main replacements that have been done in the last 5 to 10 years?
That's correct.
And do you have any knowledge, are there any lead pipes or lead issues at any of our wells?
No, not that I'm aware of. Yeah.
Thank you.
Thank you, Commissioner. Anybody else? Commissioner Sharp and then Commissioner Legree.
I just have a few questions. It was mentioned that the inventory has already begun, if I heard that correctly. And so I'm curious, what is the time frame for completion of the inventory?
Thanks, Commissioner. Yeah, so last summer when we had an intern available, so he collected all the records that we have within the water department, as well as just some anecdotal information from the folks that have been around a while. And we have a really good handle on what's in I say the public space, but a lot of that line is actually privately owned in public space. But we know a lot of information from the main to the meter. And he compiled all that for us, so we have a really good handle on that. What we don't have is the verification of what's from the meter to the house. And that's what our next step will be, trying to get access inside a house so we can look and see what the material type is as it enters the house.
So that sounds rather challenging, and I'm trying to understand how long you think that piece would even be approximated.
Well, we have 2 years. I don't think it'll take that long. But it's a challenge, as you said. And ultimately, we can always classify something as unknown. That causes us issues when you call it an unknown, because then EPA says you got to treat it as though it's a lead line. Well, we know it's not a lead line. So we've got to get rid of as many of those unknowns as possible. Because our guys, the guys that have been around here for decades, right, they have not seen a lead service line itself. Everyone has all the old ones have a lead gooseneck, a lot of galvanized, which, as I mentioned, does cause some issues, but they have not seen truly a lead pipe as a service line.
And I'm just curious, what % do you think of our customers understand that they own the issues of the service line ownership?
Not very many, Commissioner, because when they get that bill for our repairing that service line, we always end up in a long discussion about whose responsibility is and why are we sending them a bill, that kind of thing.
So I noted, and I think it's so important for the communications plan, do you know if that education is really going to be step one? That the property owners, where they own from, because I have to say that was not top of mind for me.
Sure, it's certainly an important thing to know, and we would certainly want to make sure we're pointing that out, depending upon how other discussions between now and then go.
Okay, thank you.
Mm-hmm.
Thank you, Commissioner. Commissioner Legree and then Commissioner Gossick. Commissioner Legree.
When I built my house, I was told, and I certainly told by my plumber, I think I was told that the city owned everything up to and including the meter, which is in my sidewalk. I think it's time for us to take ownership of the service laterals. I don't know why we don't do that. And for that matter, I think we should take ownership of the wastewater laterals that go to the property line. I can't believe we don't do that. And we should be charging an impact fee which will help us accomplish the tasks we have going forward. My next question is, are we at all responsible for those water line laterals and goosenecks and facilities outside the city limits? We deliver a lot of water outside the city limits of Rehoboth Beach. Are we obliged to also inventory those, which would make me ask, I've always assumed that we had about 2,000 1-inch lines in Rehoboth, and 1,500 would be, 3/4 of those, but maybe we're looking at a lot more. Help me out on some of those numbers.
Yes, sir. We are responsible for everything that we serve. So all of our 6,000 or so customers inside and outside of town we are responsible for them. Fortunately, all of our records indicate that most of them, the vast majority of the systems outside of town were created after 86, when lead was banned from use as a pipe material for drinking water systems. So most of those came off just because of when they were constructed, and then all of the other documentation we have for those, a lot of those were built, by a third party and then taken over by the city. So the records that we have on those, we didn't really find any true lead service lines outside of town. Vast majority in Rehoboth and in North Shores.
And the service lines outside of town are also owned by private people up to our main line. Is that correct?
Ooh, that's a good question, and I don't know. If our code applies to everyone that we serve, I probably doubt it.
So what I'm getting at, it might be possible for the commissioners to ask permission to take ownership of the water laterals up to the property line, if we wanted to do that, and do it by code. Our water sales makes a profit. It's not like we couldn't move a little bit of money. Needless to say, I encourage you to work hard on getting external grants or external funding, but I don't think it would be an unreasonable thing for the city to do, is to take ownership of the water laterals, but charge an impact fee for new hookups. We need to stop subsidizing the developers. Thank you.
Sure.
Commissioner Gossett?
Yeah, that's kind of a follow-up question on that. So just to understand, the service customers we service outside of the city, that infrastructure, the pipes, the laterals, et cetera, are owned by the city and maintained by the city. But if there would be a problem with it, that we would bill the homeowner for repairs?
So in the city, it's pretty clear. The code says that we would make any repairs and then bill the homeowner. Outside of town, I'm not as sure about with respect to the ownership from the meter to the main, whether that would be responsibility of the city to repair and send them the bill, or it would just be our responsibility to repair.
Well, I'm sure, well, I would think that there's some repairs been made in that circumstance in the past couple of years. Is there any records of what has happened to that?
I'm sure there are, Commissioner. I just don't know those. I mean, if
Okay.
Robert were here, he'd probably be able to answer that off the top of his head on what we've done outside of town. I just don't know.
All right, if you could supply that information for our
Absolutely.
next meeting, I'd appreciate it.
Absolutely.
Thank you.
Commissioner Gay?
Yeah, first of all, I certainly agree with everything Commissioner Legree said about taking ownership of the service lines and about the impact fees especially. And I think one of the things on your slide, Kevin, was requiring new taps for, for major reconstruction. And I think that's certainly a way to go as a starting point for the impact fees. But, I guess I am a little confused about the way we charge our own homeowners versus those we service out of town? Because my understanding is that in the county that the homeowner is not responsible for the line all the way out like we are. And so from what I hear you saying, we might have to pay for those replacements, but we're going to try to charge our own homeowners for the replacements in town. And there's something very wrong about that, in my opinion, which is perhaps one reason to look at owning the whole service line. But I guess the other thing I'm confused by is not everything that you presented today, it lines up with what's in this report that's attached to the agenda. First of all, the report is from last July, so I don't really know why we're just now. I understand the EPA's rule went into effect a couple months ago, but I don't understand why we didn't hear about it before now. But there's a great deal in there about the cost, about how it would play out over time, about what residents might be charged. So is all of that just very preliminary, and is this inventory is really going to be the answer, or what? Because that hasn't been addressed, and I'm afraid that anybody who sees this is going to perhaps be concerned about the charges that are forthcoming.
Well, Commissioner, I think if you look at the documents that, the kind of the backup documents, I mean, they were EPA, I think, documents that just kind of explain the program. The EPA has been telling us they're going to update the lead and copper rule since I was managing the DC program in 2004. Okay, so every year, oh, we're going to revise it now. Here's it's out for public comment. Oh, we're going to revise it again. It's out for public comment. Up until last fall, well, we're going to revise it again. It was supposed to have been, a year before. And so to get too far in advance of the actual rule coming out can be problematic. They actually put it out on October, whatever date, said it's effective, 3 years from that date. They immediately delayed it, said we're opening the comment period for another 2 months. So then they closed that again in December and finally issued it as a rule. So the fact that it's a couple of months or a year or a couple years old, I don't know that I would have wanted to brief you all on it, on the possibility that they were going to pass the new rule. Its discussion of any costs is really going to revolve around who's determined to own the pipe. So in our case here, when the homeowner owns the pipe all the way to the main, it's a different situation than certainly we encountered in DC or in many other places where it's more defined at the property line. So I would just offer that to you with respect to the other documents that were provided with prior to the briefing.
Okay. Okay, thanks.
Thank you. Anybody else? If not, I want to go to the members of the public. Walter Brittingham. Thank you, Walter. Carol Everhart.
She's not on anymore.
She's dropped off. And Dr. Trejos.
No comment, Mayor.
Thank you, Doctor. And Michael Strange is off. That takes care of the members of the public. Thank you, Kevin, for your hard work on that, putting the presentation together. With that, we'll go to commissioner announcements and comments. Does anybody have anything? If not, we'll go to the next, which is to review future meeting dates. I have the four following dates for Board of Commissioners meetings. Tomorrow, March 8th, 9 a.m., we have a special meeting to conduct 3 permits of compliance and hold a executive session as a personnel issue. Next meeting would be Monday, March 14th, 10 a.m. is a FOIA and ethics session for committee members specifically. But anybody is welcome to attend, and it will be noticed today. The Tuesday, March 15th, 9 a.m. is outdoor dining number 3. Friday, March 18th at 2 p.m. is a regular meeting, which we would have outdoor dining number 4, hopefully come to conclusion. We would also be considering adoption of the budget for that year. And as of March 15th, where all public meetings are being held in person. so we can see everybody's happy face without their masks. Is there any further citizen comment? Walter?
Yes, please. I'd like to say very good job to Kevin on the water report. Absolutely excellent. Thank you.
Thank you, Walter. With that, Dr. Trejos, do you have any final parting comments?
Mayor, actually, again, I just want to thank everyone for, again, allowing me the opportunity to have participated over the past 2 years. I've gotten to know all of you very well, and I just wish you the best for the future. And hopefully, again, I will continue to participate in writing. And when certain issues do come up that require my attendance, I look forward to seeing you in person over in the City Hall. And thank you so much.
Very good. Thank you, Doctor. We appreciate it. If there's no further comments, then call this meeting adjourned at 11:45 a.m.